At the Global South Network, we are deeply committed to promoting interdisciplinary and cross-regional conversation. Our mission has always been to create an inclusive platform where judges, academics, lawyers, and civil society actors from across the Global South and beyond can exchange ideas, share good practices, and learn. On behalf of the network, I am deeply honored to welcome our distinguished speaker, the Honourable Justice Peter Jamadar, Judge of the Caribbean Court of Justice, Vice President Programming of the Commonwealth Judicial Education Institute, and Chair of the Caribbean Association of Judicial Officers.
After all, what would you do as a colonizer from the global north, conditioned by a systemic othering mindset and driven by economic lust built on commodification, including the commodification of human beings? You came upon a series of lush islands with white sands, beaches that are caressed by warm turquoise blue water. But what did they do? They enjoyed the bliss and exploited the people and land for their own benefit. For locals and for commentators from the global south in the Caribbean, colonized, first of course the indigenous, the first peoples, and then imported forced labor in our region, their experience and reflections are that surf, sand, and sea can be tragic reminders of encounters with inhumane, cruel conquerors. For the first peoples of the Americas and the Caribbean, it is from over the sea and through the surf that these colonizers came in their boat, landed on the Caribbean's pristine sand beaches, turned their turquoise waters, their Caribbean seas red with the blood of so many innocents. However, not only were people and lands and resources colonized and exploited, and the point of today's talk is about fact that colonizations of our legal imagination has also been an enduring legacy of colonial history of Caribbean people. Insofar as we are considering, of course, the colonization of Caribbean legal imagination, however, our freedom in this regard remains somewhat fraught. There are still 7 independent and sovereign Caribbean states that take their final appeal to London, to the Judicial Committee of the Privy Council, and that is to say, to the historical colonial. These, Trinidad and Tobago, became a republic, not just independent, a republic in 1976, but still remains having the JCPC as its apex or final court of appeal. How can Caribbean peoples free ourselves from this mental slavery that has captured our legal imagination? Have we been developing a truly Caribbean jurisprudence? After all, I think we can all agree that if a seed is transplanted into new soil in new conditions and tended by different hands, these seeds will grow and flourish in distinct ways. That has been true in the Caribbean, as it has throughout the global south. Well, there can be no social jurisprudence separated from social context. And so social context is critical to this idea of a Caribbean jurisprudence, because it would be quite heretical to insist that there is one Caribbean flavor. Caribbean peoples would revolt. And in the same way, there is no one Caribbean flavor. So too with our cultures and society. Are there commonalities? Of course there are. Are there differences? Absolutely. And if so, in all these fields, why not in our jurisprudence? Indeed, the CCJ in McEwan's case say, and I quote, differences as natural as breathing. Infinite varieties exist of everything under the sun. That recognition, this court would demand respect and opportunity for self-actualization of the claimants in that case. One size does not and cannot fit all. And that imperial magisterium, I hope, has finally been recognized as fraught. And attempts to return to universalizing of the law is a return to the imperial model of governance, which I think Caribbean independent constitution tried to put behind us. The global south, all of us, understand that difference is natural. It's to be celebrated, and that this is true as well in the field of law. There are in the global south states where multiple legal systems coexist. And so in several North African states, tribal and customary law, Sharia law, and national state laws and court systems function together. Nigeria is a great example because this is all contained within constitutional documents. But what does it do? It reflects the unique socio-legal context that exists in these places. The dragon needs to dance. Not enough for the dragon to be acknowledged, recognized, given textual support. The dragon needs to dance. Prudentially, therefore, there is much at stake in this discourse on Caribbean jurisprudence. Much more than just freedom from some no longer useful colonial ideas. What is at stake is the idea of freedom itself, the desire for state selfhood and state and self-society, individual actualization. The dragon needs to dance. The making, interpretation, and application of law is, and we need to recognize this, deeply epistemological, therefore foundational to how we know and how we come to know and understand and experience ourselves as people and society. Laws made and imported from across processes and imposed in these lands have epistemological implications. As judicial officers, I dare say, we are often, as Anais Nin said, we don't see things as they are, we see things as we are, and we are often still in an unemancipated state of mental slavery around these legal ideas. Our legal imaginations are still captured. We do not exist in a parliamentary democracy where parliament is supreme. We exist in a constitutional democracy in which the constitution is supreme and normative. And thus, unlike in the UK, where among the three branches of government, the executive, legislature, and judiciary, the legislature is supreme. In the Caribbean, this is not so, and not intended to be so. If anything, the judiciary is primus inter partes, first among equals. Why? Principally because in Caribbean constitutions, courts can strike down laws and executive actions by way of constitution. Caribbean parliaments are not at liberty to legislate whatever or however they see fit without having regard to the limits enshrined in the constitutions, which ultimately have to be construed and guarded by the judiciary.
Initiative.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provide a platform for meaningful dialogue and collaboration, fostering efforts to build a more equitable and resilient legal landscape.
GSN network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is, I believe, the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
كانت جزء لا يتجزأ من الدولة العثمانية.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Quiero expresar mi sincero agradecimiento al Dr. Nauman Riad.
Dr. Nauman Riad, the founder and convener of the Global South Network, his visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas. Initiatives like today's dialogue allow us to compare jurisprudence, share best practices, and develop common principles. This has the potential to contribute to transnational standards in procedure and enhance administrative law globally.
I would like to point out that Dr. Riad's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism.
We can rule when we want in the cases which are brought to us by citizens and residents. In the EU, this openness of mind is increased by the fact we apply, in some cases, same norms from the EU treaties or the EU directives or regulations.
Good morning. morning, good evening to all joining us from different parts of the world. I am Dr. Nouman Riayat, the Chief Convener of the Global South Network and a lecturer in law at the Leicester Law School, University of Leicester. It is a great pleasure to welcome you to today's lecture organized under the Global South Network Judges Guest Lecture Series. On behalf of the network, I am deeply honored to welcome our distinguished speaker, the Honourable Justice Peter Jamadar, Judge of the Caribbean Court of Justice, Vice President Programming of the Commonwealth Judicial Education Institute, and Chair of the Caribbean Association of Judicial Officers. Justice Jamadar's lecture titled Sea, Surf, Sand, the Caribbean Court of Justice, Developmental Approaches to Caribbean Constitutionalism could not be more timely in an era when constitutionalism in many parts of the world is being tested by political transitions, social transformation, and the rise of new technologies. The Caribbean experience offers both inspiration and critical reflection. The developmental approach adopted by the Caribbean Court of Justice demonstrates how constitutional principles can be contextualized, deeply rooted in regional history, yet responsive to contemporary challenges of justice, democracy, and governance. At the Global South Network, we are deeply committed to promoting such interdisciplinary and cross-regional conversations. Our mission has always been to create an inclusive platform where judges, academics, lawyers, and civil society actors from across the Global South and beyond can exchange ideas, share good practices, and learn from each other's experiences. In connecting judicial voices from regions as diverse as Caribbean, Africa, Asia, and Latin America, we aim to bridge knowledge gaps and encourage a richer, more plural understanding of law and constitutionalism. In this regard, the network has been running weekly online seminar series on every Wednesday, 3 to 4 UK time, during which PhD candidates from all over the world share their PhD projects focusing on distinct areas of politics, law, and other areas of arts, humanities, and social sciences of the Global South, and guest lectures of Supreme Court judges from all over the world. Today's lecture continues that mission, linking the Caribbean's evolving constitutional narrative with the broader dialogue on justice and institutional independence across the Global South. We are truly privileged to have Justice Jamadar with us today, and we look forward to an engaging and thought-provoking discussion that will deepen our collective understanding of how constitutional values can be strengthened through regional collaboration and shared commitment to justice. The Honourable Justice Jamadar, thank you for joining us and welcome to the Global South Network. I invite you to deliver your lecture. The screen is now yours.
Thank you very much, Dr. Riayat, and thanks to the Global South Network for the invitation and opportunity. And welcome to everyone who has joined this talk live from wherever in the world that you are. Welcome. What I thought I can start with for everybody's benefit is just a little bit of an overview and a map so that we'll understand what I propose to do over the time that we're going to spend together. What then would be a synopsis of what I want to try and share with you this today, I should say, because in some parts of the world, here in Trinidad, by the way, where I am, where the CCJ is, it's still mid-morning, but I know that in London it's 3 o'clock, and in other parts of the world, of course, the time is all very different. So welcome to all of you, as I said. What I want to do is to explore how the CCJ, I'll use that as the acronym, the Caribbean Court of Justice, how the CCJ has shaped and advanced Caribbean constitutional interpretation and development across the Caribbean region. My talk will focus on the CCJ's constitutionally informed jurisprudence, in highlighting its progressive and developmental right-centric rights privileging, and you're going to hear me use that expression a bit, right-centric and rights privileging approaches to key areas of legal interpretation. If I have the time, I'm going to try and cover 7 areas, and these would be the rule of law, protection of the law, and the basic deep structure doctrine, savings law clauses and human rights and freedoms, statutory interpretation, state contracts, gender judging, social justice issues, and preambular clauses. I'm going to use as a unifying thread the Caribbean novelist, poet, philosopher Earl Lovelace's dragon, and use the metaphor of the dragon dancing as symbolizing the CCJ's active role in reclaiming Caribbean jurisprudential sovereignty, freedom, and self-actualization. Maybe at the end of the day, what you will hear coming from this conversation is a call for a distinct and transformative Caribbean jurisprudence, one that is locally, that is to say, both territorially and regionally rooted, rights-focused, and ideologically emancipated from what I call a no longer useful colonial set of legal legacies. So let me therefore start with a little bit of a reading from The Dragon by Earl Lovelace, just to set the context, and I'm going to use the dragon, as I said, as a handle as we go along to cue in some of the shifts in the talk. And this excerpt goes as follows. With the door of his little shack half open, Ulrich worked solemnly on his dragon costume, saying nothing to Basil, the little boy of 10, who came from somewhere in the neighborhood, looking from the costume to Ulrich with a fullness of wonderment and fascination and awe. In truth, it was in a spirit of priesthood that Ulrich addressed his work, for the making of his dragon costume was for him always a new miracle, a new test, not only of his skill, but of his faith. For though he knew exactly what he had to do, it was only by faith that he could bring alive from these scraps of cloth and tin that dragon, its mouth breathing fire, its tail thrashing the ground, its 9 chains rattling, that would contain the beauty and terror that was the message he took. It was in this message that he asserted before the world himself, and it was through it that he demanded that others see him, recognize his personhood, and be warned about his dangerousness. So, that is the metaphor that I want to use as we begin. Surf, sea, and sand. These words usually evoke images of Caribbean bliss in the global north, but there is always more than meets the eye as first impressions. And A.S. Nin now infamously has noted that we don't see things as they are, we see things as we are. Our preconceptions condition the way we see the world and how we come into relationship with it. So for English and European powers, colonial powers, the Caribbean may have been seen and used as a tourist getaway, even when it hosted plantation economies built on forced labor and epitomized in the use of indentured labor, trafficking in humans, and chattel slavery. After all, what would you do as a colonizer from the global north, conditioned by a systemic othering mindset and driven by economic lust built on commodification, including the commodification of human beings? If you came upon a series of lush islands with white sands and beaches, and beaches that are caressed by warm turquoise blue waters. But what did they do? They enjoyed the bliss and exploited the people and lands for their own benefit. For locals and for commentators from the global south, in the Caribbean, the colonized, first, of course, the indigenous, the first peoples, and then imported forced labor in our region, their experience and reflections are that surf, sand, and sea can be tragic reminders of encounters with inhumane and cruel conquerors. For the first peoples of the Americas and the Caribbean, it is from over the seas and through the surf that these colonizers came in their boats, landed on the Caribbean's pristine sand beaches and turned their turquoise waters, their Caribbean seas, red with the blood of so many innocents. However, not only were peoples and lands and resources colonized and exploited, and the point of today's talk is about the fact that the colonizations of our legal imagination has also been an enduring legacy of the colonial history of Caribbean peoples. And so it is this that we want to explore today, very much like Ulrich and Lovelace's Dragon Can Dance, and seek to, and I quote, bring alive from these scraps of cloth and tin that dragon, That is our message, asserted before the world, the message of our legal and jurisprudential selfhood. In 1937, Marcus Garvey, speaking in Nova Scotia in Canada to Caribbean and North American, African communities, said, "We are going to emancipate ourselves from mental slavery because whilst others might free the body, none but ourselves can free the mind." These thoughts of Garvey have been immortalized by the Jamaican reggae leader and legend Bob Marley in his redemption song, and I hope many of you know these words: "Emancipate yourselves from mental slavery, none but ourselves can free our minds." How else can we work out for ourselves the real things of life if we cannot emancipate ourselves? Well, in the Caribbean, the first Anglo-Caribbean states got independence in the 1960s, and that's over 60 years ago. Whatever else may be said about the Caribbean independence projects, this much is certain. It intended, one, to be a break from the past, models of governance, and secondly, freedom into new beginnings of self-determination. I think those two things are important. It is both freedom from and freedom into. Insofar as we are considering, of course, the colonization of Caribbean legal imaginations, however, our freedom in this regard remains somewhat fraught. One notable feature of Anglo-Caribbean independence remains incomplete. And what is that? That is to say that there are still 7 independent and sovereign Caribbean states that take their final appeals to London, to the Judicial Committee of the Privy Council, and that is to say to the Historical Colonial Court. These, Trinidad and Tobago, became a republic, not just independent, a republic in 1976, but still remains having the JCPC as its apex or final court of appeal. In spite of that, however, for Caribbean jurisprudence, there are questions. How can Caribbean peoples free ourselves from this mental slavery that has captured our legal imaginations? And have we been developing a truly Caribbean jurisprudence? And so that's what I want to talk about today. That is to say, how the Caribbean Court of Justice, how its developmental approaches to Caribbean constitutionalism may be addressing these independence goals of a break from past models of governance and a freedom into the beginnings of self-determination and actualization. Well, if Caribbean independence is of relatively recent vintage, the CCJ is even more so. In fact, after independence, most Caribbean states kept going to the Privy Council. But by about the 70s and 80s, regional leaders began recognizing there's a need for a final Caribbean court. A good example of that, in fact, was something called the Granans Declaration in Grenada, which expressly called for this. And in this sense, the CCJ was intended and is seen and intended to function as a symbol of and an agency for judicial independence and the realization of regional sovereignty and integration. CCJ was established by the agreement establishing the CCJ in February 2001 in Port of Spain in Trinidad. It was inaugurated in April 2005, also in Port of Spain, and the seat of the court is in Port of Spain. Notably, it is funded by something called the Caribbean Court of Justice Trust Fund. I call it the fund. And it is set up to guarantee the court's autonomy and independence and insulate it from political or other external interference. And this is a very unique feature of the court. The court has a dual jurisdiction. In its original jurisdiction, it interprets and applies the revised Treaty of Chaguaramas, what we call the RTC, which established something called the Caribbean Community Single Market and Economy, which is a trade arrangement between the sovereign island states or Caribbean states. In its other jurisdiction, I said it had 2 jurisdictions, which is its appellate jurisdiction. Here it serves as a final apex municipal court for appeals in civil and criminal matters. And in this sense, it replaces the JCPC for territories that have withdrawn from the JCPC, the exception being Guyana, because Guyana actually, when it became a republic, did away with the Peace and Privy Council and held as its Court of Appeal as its final appellate court. So, the CCJ is a hybrid court. And thus, what I'm hoping that you will already begin to grasp that the CCJ is unique in its structure, funding mechanisms, and dual jurisdictions. In this way, from conception and design to implementation, structurally and jurisdictionally, it is developmental. It has been locally imagined, conceived, funded, and rolled out to suit the needs of Caribbean people. The dragon is imagined. You remember the dragon metaphor? And here I want to use that to start talking about a conscious developmental ideology. In the agreement establishing the CCJ, the first preamble clause says, and I quote, "The contracting parties convinced that the Caribbean Court of Justice will have a determinative role in the further development of Caribbean jurisprudence hereby agree." So right away you see from the very beginning, this preambular clause telegraphs both the intention and purpose at the point of inception for the court, the CCJ, to play a determinative role in the further development of Caribbean jurisprudence. A decade later, 2011, Sir Sridhar Ramphal, the longest-serving Commonwealth Secretary General and a very distinguished Caribbean thinker, would speak in Port of Spain at a lecture put on by a Judicial Education Institute, the Trinidad and Tobago Judicial Education Institute, on a topic called Creating a Regional Jurisprudence. And he would say, and I quote, "Creating a regional jurisprudence is inseparable from the issue of the Caribbean Court of Justice. But there is more besides that needs to be said, more about philosophy than about structures." And so I underline that for the moment, more about philosophy than about structures, because what that begins to say to us, that creation is one thing, but a conscious ideology is another. And so that what Sridhar is saying, in effect, is an outright ideological call for developmental approaches to Caribbean jurisprudence. And it is these insights, some foundational to the court as written warrant in the agreement, and others aspirational as a spoken word uttered by eminent Caribbean luminaries such as Sir Sridhar, that in a sense have defined the banks within which the CCJ's rivers of jurisprudence have flowed over the past 20 years. And so I just pause to note for you that in 2025, the Caribbean Court of Justice celebrates its 20th anniversary, 20 years since its inauguration. And for me, very much, speaking about this topic at this forum is in celebration of this 20th anniversary. Already the jurisprudence of the court demonstrates the truism, and I quote, that the life of the law has not been logic, it has been experience. And the Caribbean developmental jurisprudence demonstrates this. Let's take another step. Caribbean jurisprudence with Westminster. What is this Caribbean jurisprudence? No doubt, as with all the Commonwealth nations in the Anglo-Caribbean, our states are shaped by the common law traditions of England. But this is not the whole picture. It is not only the British who colonized the Caribbean, so did the Spanish, French, and Dutch. And there are therefore also Roman and civil law, legal antecedents, and influences at play in the region. In St. Lucia, for example, there is an operative St. Lucia civil code, and in Guyana, Roman Dutch laws and legal traditions continue to be extant. Mixed legal traditions exist in Anglo-Caribbean states, and the CCJ administers and determines matters that involve and have bearing on and are influenced by both the St. Lucia civil code and Roman Dutch traditions and laws in St. Lucia and Guyana, respectively. However, beyond these more structural and systemic aspects, Caribbean constitutional law has been in a sort of love-hate relationship with what is called the Westminster model of constitutions. That is to say, written constitutions supposedly model after the British Westminster model. Very early in the development of constitutional jurisprudence, in a case called Hines versus R, Lord Diplock in the Privy Council would assert, and I quote, "They can be discerned in all these constitutions," we're speaking about Caribbean written constitutions, "which have their origin in an act of imperial parliament at Westminster or in an order in council, a common pattern and style of draftsmanship which may conveniently be described as the Westminster model." However, very early on, leading constitutional and Caribbean scholar Professor Ralph Carnegie would critique this claim, suggesting that when we speak of our Westminster model constitutions, we are not being lawyers or even political scientists. We are at best being poets. For him, references to Caribbean constitutions being Westminster models had more to do with the need for, and I quote, "psychological comfort" than textual or lived realities. So why would Professor Carnegie say something like that? Well, he was writing in the 1980s when Caribbean constitutional thinkers were beginning to question the continued uncritical acceptance and even dominance of British constitutional ideas in the interpretation and application of Caribbean constitutions. But Caribbean constitutions were not, and are not replicas of Westminster. They are written, supreme, and justiciable. Courts had a constitutional power and duty to review legislative and executive actions. That is to say, governmental power. And so fundamentally, the Anglo-Caribbean constitutional order has shifted from British parliamentary sovereignty to constitutional supremacy. And so what I want to suggest at this point, as we take another step, is to suggest that what Professor Carnegie was in fact calling for was the emergence of a distinct Caribbean jurisprudence, rooted in Caribbean realities, conscious of Caribbean history and society, and normatively transformative. What do I mean by that? I mean that the law, to be normatively transformative, the law must act as an instrument to realize the social and moral aspirations of true Caribbean independence. I'm not for a moment suggesting that the conventions at Westminster are no longer useful or helpful, because after all, Lord Diplock was not wrong when he said that the origins are in an act of Parliament at Westminster or in an order of council from the monarch. But it is to say that Westminster ideologies ought not to be uncritically applied in Caribbean contexts. After all, I think we can all agree that if a seed is transplanted into new soil in new conditions and tended by different hands, these seeds will grow and flourish in distinct ways. And that has been true in the Caribbean, as it has throughout the global South, where the common law has been transplanted and taken root. 3 steps forward, Caribbean jurisprudence. What may be this idea of Caribbean jurisprudence? Well, first, it is necessarily about authentic and indigenous legal thought, principles, insights, methodologies, and philosophies that have all emerged from and been developed in Caribbean context for Caribbean peoples. Second, it is about Caribbean identity. Caribbean identities as sovereign democratic states in which there is constitutional supremacy, where fundamental rights and freedoms are entrenched, that is to say, they are prioritized and privileged, and as well, Caribbean identity as a region in which regional integration is a cultural, social, and economic activity grounded in, as I've said it earlier, in the revised Treaty of Chagarama. So already you see that this idea of identity and regionalism, both individual and regional, begin to find some sort of home and culmination in the CCJ as it sits in its dual jurisdictions. The third aspect of identity is the idea of Caribbean jurisprudence being deeply philosophical. A very eminent Caribbean academic, Professor Simeon McIntosh, has pointed out, our constitutions are not merely legal instruments for the distribution of powers and the definition of rights and duties. And many jurists get stuck at that point. But Professor McIntosh says something more. They embody a moral vision of the good. Now, by this, he does not mean morality as in religious morality. He means morality as a philosophical and ethical system of thought and action. They embody a moral vision of the good life, conception of the just political order that provides the ultimate standard by which the legitimacy of governmental action is to be judged. Hence the role in Caribbean constitutions of the courts as having the duty and power of constitutional review. So therefore, for McIntosh and Carnegie and others, Anglo-Caribbean independence constitutions are not just legal or procedural textual instruments. You know that expression, we have to move beyond tabulated legalisms. No, rather they are constitutive documents, sui generis, we'll come to that, foundational socio-political moral charters that express the collective aspirations of post-colonial Caribbean people for true sovereignty, meaningful democratic governance, and the flourishing of fundamental rights and freedoms. Caribbean jurisprudence is thus both descriptive. It describes the ways, the hows and whys in which the legislature, lawyers, judicial officers engage the processes of lawmaking, interpretation, and application. But it's not just descriptive, it's also normative. This is very important. Caribbean jurisprudence is normative because it declares what this Caribbean jurisprudence is and does as a working legal system and set of principles, values, and frameworks that have real-life impact in Caribbean societies. Therefore, to assert that Caribbean jurisprudence is developmental is to recognize that it is an evolving process. What does that mean? It means that it is responsive to emerging cultural realities, unfolding socio-legal norms, and changing human values and experiences, all of which is happening in fluid political and legislative actualities. And so this idea of Caribbean jurisprudence, as we in the world, both North and South, exist in a time of change, of upheaval, global, that is to say, change and upheaval, this model of a developmental Caribbean jurisprudence that can be responsive to changing realities begins to have not just relevance for the Caribbean, but as a model relevance for the entire democratic global order and justice sectors. And therefore, just to be clear, when we talk about the development of Caribbean jurisprudence, it's not a call per se for discontinuity from our common law traditions. But as Sridhar has pointed out, we in the Caribbean, and maybe also true for some of you in the global South elsewhere, we often make a logical virtue of uncritically holding on to the coattails of our past and fail to embrace the lived experiences and the philosophical underpinnings and the deep felt longings of our present into the future. And that is what is happening in Earl Lovelace's The Dragon Can't Dance. This deep felt longing for the present into the future of self-actualization. The dragon emerges. Well, there can be no social jurisprudence separated from social context. Coming from Trinidad, I would say that would be like trying to make bread or roti without water and flour. And from those of you who know how to make bread or roti, you would understand that you cannot make it without water and flour. And so social context is critical to this idea of a Caribbean jurisprudence. Much like our Caribbean cuisine, to go a little further, because it would be quite heretical to insist that there is one Caribbean flavor. Caribbean peoples would revolt. And in the same way, there is no one Caribbean flavor, so too with our cultures and societies. Are there commonalities? Of course there are. Are there differences? Absolutely. And if so, in all these fields, why not in our jurisprudence? Indeed, the CCJ in the case, McEwan's case, would say, and I quote, "Difference is as natural as breathing. Infinite varieties exist of everything under the sun." And in that recognition, this court would demand respect and opportunity for self-actualization of the claimants in that case. It would seem to me then that the agreement establishing the CCJ was astute not to speak of a Caribbean jurisprudence as a single universalizing monolith, but rather about, and I quote, the further development of Caribbean jurisprudence. And this open-ended approach to the development of Caribbean jurisprudence recognizes the Caribbean's multiple contexts and nuances. One size does not and cannot fit all. And that imperial magisterium, I hope, has finally been recognized as fraught, and attempts to return to universalizing of the law is a return to the imperial model of governance, which I think Caribbean independent constitutions have tried to put behind us. The global South, all of us from the global South, understand that difference is as natural as breathing and is to be celebrated. And that this is true as well in the field of law. There are in the global South states where multiple legal systems coexist. Very recently, I've had conversations with colleagues from Nigeria. And so in several North African states, tribal and customary law, Sharia law, and national state laws and court systems function together. Nigeria is a great example because this is all contained within the constitutional document. But what does it do? It reflects the unique socio-legal context that exists in these places. The dragon needs to dance. It's not enough for the dragon to be acknowledged, to be recognized, to be given textual support. The dragon needs to dance. Jurisprudentially, therefore, there is much at stake in this discourse on Caribbean jurisprudence, much more than just freedom from some no longer useful colonial ideas. What is at stake is the idea of freedom itself, the desire for state selfhood and state and self, society and individual actualization. The dragon needs to dance. The making, interpretation, and application of law is, and we need to recognize this, deeply epistemological, and therefore foundational to how we know and how we come to know and understand and experience ourselves as people and society. Laws made and imported from across the seas and imposed in these lands have epistemological implications. And as judicial officers, I dare say, we are often, as Anais Nin said, we don't see things as they are, we see things as we are, and we are often still in an unemancipated state of mental slavery around these legal ideas. Our legal imaginations are still captured. And so the idea of developing Caribbean jurisprudence is therefore deeply epistemological, and in this endeavor, unavoidably ideological. The CCJ's endeavor, as mandated by its constitutive document of furthering development of Caribbean jurisprudence through the judicial process, therefore becomes ultimately an embracing of Caribbean nation states' independence, sovereignty, and democratic aspirations. The dragon has permission to dance. CCJ in its decisions has identified the interpretive role of the agreement establishing the court. So, for example, in a case of Lalchan and Supal, a 2024 decision, the court pointed out the agreement establishing the Caribbean Court of Justice declares that the CCJ court will have a determinative role in the further development of Caribbean jurisprudence. It is this is what the court says, it is this responsibility that informs the above analysis and what follows. And so this is actually become an operating principle of the CCJ, and therefore a developmental approach. The dragon can dance constitutional common law. The dance of the dragon finds its fullest expressions in the CCJ's right-centric, right-privileging jurisprudence. Given the Anglo-Caribbean English colonial history, this development necessarily plays out against the backdrop of English colonial history and principles, including the common law. And in this sense, the CCJ is unavoidably engaged in a post-colonial jurisprudence, even as it is encumbered by the realities of coloniality. And one significant assertion of indigeneity by the CCJ is how it is tapping into the inherent developmental potential of the common law. As this court said in a case OO versus GK, the common law is not past the age of childbearing. Indeed, the CCJ would note with approval in Lalchan and Supal, and I quote, Richard Albert explains how decolonial approaches to lawmaking and interpretation are enacted in these times. The protagonists are no longer soldiers and generals, they are politicians, lawyers, and judges. Writing about the Caribbean Court of Justice, Albert would opine, this is in the case of Lalchan and Supal being cited. Quote, it is a decolonial institution with a decolonial mission intended to repatriate to the Caribbean the development and control over the common law. And so in the Anglo-Caribbean, consistent with its common law heritage, there has also been a developmental emergence of constitutional common law. With JCCJ, in the seminal case of the AG of Barbados versus Boyce and Joseph, and within 1 year of the CCJ's beginning, explains, and I quote, the interpretation of Caribbean constitutions is a legal activity in its own right. The English common law cannot be the point of departure of Caribbean constitutional law because that common law is focused on the unwritten English constitution, which is fundamentally different from Caribbean constitution. So here we see already from the very origins of the CCJ's jurisprudence, the judicial imprimatur, as it were, for the emergence of a distinct Caribbean constitutional common law. And it is this endeavor that the court has most demonstrated its capacity to, quote, repatriate to the Caribbean the development and control of the common. Thus, the CCJ has recognized the need to develop the general Caribbean common law to align with constitutional standards, particularly when existing common law does not provide adequate relief or it does not properly reflect constitutional values and norms. And so in another case, Lucas versus the Chief Immigration Officer and others, Justice With again would point out, in relation to Belize, although the Constitution of Belize does not specifically provide that the common law should be developed to bring it up to par with constitutional standards, it is certainly not prohibited from doing so. And I would think that this includes an invitation to mold and develop the common law in order to make it more just, fair, and consistent with constitutional standards. So what we begin to see happening is a development of an approach, not just to the Constitution per se, but to all law per se, where the constitutional values and standards become the operating lens for interpretation and application of all law. It also therefore demonstrates the CCJ's commitment to ensuring that constitutional principles are upheld and that a Caribbean common law evolves to meet the needs of Caribbean societies. What I want to move to now, just looking at time, is what I call constitutional context and conundrums. And I'll maybe go over this a little quickly to get on to something that I do want to cover before we end. I don't think I need to do too much about the context for Caribbean constitutions because Caribbean constitutions organize their states according to the architecture of the constitutions. And if you use Belize as an example, the constitutions are the supreme law. They declare states to be sovereign democratic states. The rule of law is foundational. They all have entrenched certain fundamental rights and freedoms. And what we can take away from that, from those key points, is that Caribbean states have opted for what I call a right-centric, rights-privileging model of constitutional democratic governance that permeates all aspects of the state and restrains all exercises of state power. In the UK, however, parliamentary sovereignty is constitutionally normative. The UK is thus referred to as a parliamentary democracy. Understandably, very rationally actually, leads to how doctrines such as the separation of powers are epistemologically experienced and articulated. But if we get that, then we will also get that in the Caribbean, our point and process of constitutional embarkation, they are radically different. We do not exist in a parliamentary democracy where parliament is supreme. We exist in a constitutional democracy in which the constitution is supreme and normative. And thus, unlike in the UK, where among the three branches of government, the executive, legislature, and judiciary, the legislature is supreme, in the Caribbean, this is not so, and not intended to be so. If anything, the judiciary is primus inter pares, first among equals. Why? Principally because in Caribbean constitutions, courts can strike down laws and executive actions by way of constitutional review. Going back to Justice Witt from the CCJ, he would again say in that seminal case of Joseph and Boyce, and I quote, Caribbean parliaments are not at liberty to legislate whatever or however they see fit without having regard to the limits enshrined in the constitutions, which ultimately have to be construed and guarded by the judiciary. And so there is a post-colonial constitutional dissonance that is going on here. The dissonance is between what happens when epistemologically and ideologically you start with a sense of parliamentary sovereignty, compared to when you start from a point of constitutional supremacy, in which, as I've explained, human rights are entrenched and privileged, and courts are primus inter pares, first among equals, with the right to strike. Well, there's a case that came out from the Privy Council in 2022. I call it J. Chandler's case, and it sort of demonstrates this very nicely. The issue was whether the constitutionality of the mandatory death penalty, whether it was saved from constitutional scrutiny by General Sabin's law clauses in a constitution. The Judicial Council of the Judicial Committee of the Privy Council, and everybody agrees that mandatory death penalty, death by hanging, is unconstitutional. That's not in debate at all. It's whether that unconstitutional law, meaning a law that does not meet the fundamental rights and freedom standards in the written constitutions, but in unconstitutional essence, whether that law is saved and therefore constitutional. But the case brought into sharp relief the differences between the CCJ and the JCPC. And so what happens is the JCPC in 2004 in Boyce versus the Queen says no, Sabin's law clauses govern, and so even though these laws are in breach of fundamental rights, they are saved and therefore they are constitutional. You can execute by hanging under a mandatory death penalty. In the interim, that is to say between 2004 and 2020, before J. Chandler comes before the JCPC, something happens in the Caribbean. The CCJ in two cases, in Nerve-NR and in McEwan, they have to determine the very issue. In Nerve, question becomes whether or not the Sabin's Law clause is going to trump, as it were, fundamental rights and freedoms. And President Byron would say, infamously so now, quote, General Sabin's clause is an unacceptable diminution of the freedom of newly independent peoples who fought for that freedom with unshakable faith in fundamental human rights. The idea that even where a provision is inconsistent with a fundamental right, a court is prevented from declaring the truth of that inconsistency just because the laws form part of the inherited laws from the colonial regime must be condemned. In 2018, in McEwan, the CCJ had to determine similar question of the Sabin's Law clause, and this time it was in relation to a law in which it made it an offense for a man to wear female clothing in a public place for an improper purpose. An old colonial law intended to bring about public order. And former president of the CCJ, President Saunders, then Judge Saunders, would say, if one part of the Constitution appears to run up against an individual fundamental right, then in interpreting the Constitution as a whole, court should place a premium on affording the citizen their enjoyment of the fundamental right, unless, of course, there is some overriding public interest. So what you now see is the CCJ taking a very different approach from the JCPC and saying, hold on, even if you have two provisions in a constitution, there's a hierarchy of values, and fundamental rights and freedoms must be privileged and prioritized, unless, of course, there's an overriding public interest. So in J. Chandler, the JCPC had to now determine, and it allowed the appeal on this basis, whether or not it was going to follow the CCJ's right-centric, right-privileging approaches. And they declined to do so. They declined to do so, relying on this doctrine of stare decisis, choosing judicial restraint and deference to Parliament. So they would say, about the Savings Law Clause. Nonetheless, such a provision is not unconstitutional. The Constitution has allocated to Parliament as a democratic organ of government the task of reforming and updating the law, including such laws. So in this approach, the JCPC has eschewed the living tree approach espoused by the CCJ, as well as the CCJ's assertions that the separation of powers and the rule of law can function as an overriding constitutional imperative. What the CCJ has done in Nerve and McEwan is set out its right-centric, rights-privileging approach to constitutional review. And I'm going to use that to jump very quickly how this privileging of rights and freedoms plays out in the CCJ's jurisprudence. I have tried to describe to you some contextual history, so let's see how it actually plays out. For the CCJ, the courts are the ultimate guardians of democracy. They have the sole and singular responsibility of making sure that executive actions, actions, and laws, legislative actions, in the exercise of governmental power, meet constitutional standards. In this exercise, they privilege fundamental rights and freedoms. And so, to keep the metaphor going, the dragon is now dancing. I'm going to talk about something that the CCJ explains as chaastic approaches. In a sense, Garvey's plea for people, Caribbean people, to emancipate themselves from mental slavery has taken root in the CCJ's developmental approaches. We have already seen how they privilege fundamental rights. But in Marin and the Queen, which is a 2021 case, in a unanimous judgment of the court, it shared its conceptual approach to its developmental constitutional jurisprudence. It did so by coining a phrase, a chaastic jurisprudence. To describe this, it said, what has begun to emerge is a sort of chaastic analytical pattern, emerging out of a resonant chaastic epicenter to the approaches to Caribbean constitutional interpretation. It is inclusive and encompassing. It is a pattern in which there is an evolutionary flow towards greater symmetry and a balancing of parts of what is a movement towards a more unified interpretive whole. And so that already you begin to see that in the Savings Law Clause jurisprudence. Try and find a way to create a unified approach to constitutional interpretation and to the interpretation and application of all laws. The center point for the court that Marin draws attention to, that was not new in Marin, but just consolidated, was that Caribbean constitutions are supreme and sui generis. And therefore, the interpretation is a legal activity in its own right. And part of this process must include what we call the local and regional Sitz und Leben, life settings of the law. Part of the process also included ideological considerations. For example, this interpretation is guided by the principle of giving full recognition and effect to fundamental rights and freedoms, prioritizing that. They are open-minded, generous, broad, purposive, treat the Constitution as a living instrument. They are present and future-facing, and therefore prefer to adopt a consequentialist approach to legal interpretation and application, determining what is the effect of the law, what are the underlying values, and which should we choose when we have to make choices. They must be democratically justifiable. Again, this idea of a unifying whole, and they are consciously independent and developmental, which, as I explained from the very beginning, is very much the mandate of the CCJ. What then are some practical consequences? I'm going to run through these quite quickly and try to see if I can get through, just at least you get a flavor of it, what I call 7 areas. First, and we've covered this in a way, the CCJ is asserting that constitutional values and principles of the rule of law and the protection of the law are normative and can be independently enforced. Now, just to make the point that the JCPC in Chandler's case has said they don't agree with that. So this is a divergence in the jurisprudence. Second, by classifying a constitutional value or principle or feature as part of the basic deep structure of a constitution, that means certain non-derogable features, principles, or values, such as the rule of law, protection of the law, an independent judiciary, the separation of powers. What becomes normative actually is not necessarily the letter of the law, the letter of the text, but the basic deep structure, values, principles, and features that inform, underpin, and constitute the text as a constitution. In Nervin and Severin, that's actually the what happens. Why? Because it says the literal text of the Constitution. Remember, there's a section of the Constitution saying that laws are saved. The literal text of the Constitution, the same as law clauses in those cases, is not inviolable and is at once subject to certain basic underlying principles. Third, state contracts and administrative good governance are also subject to these fundamental constitutional values and principles. In another case, Belize International Services, the court would assert the state is under the Constitution obliged to treat with contracting parties in accordance with the rule of law, not understood as a mechanical but as a rich and normative principle, and flowing therefrom the principle of good governance. So what you see now is the court taking this idea of right-centric, right privileging, taking the idea of basic deep structure, values, features, and principles, and applying it now throughout the legal order, as it were. Fourth, general statutory interpretation is also significantly impacted by the Chaastic jurisprudence of the CCJ, this whole unifying approach. In A.G. and Thomas, the CCJ would explain, in this appeal, several matters of statutory interpretation have generated anxious argument before the court, and they were amenable to rational lines of reasoning, meaning that in the case, you could argue rationally and reasonably position A or position B. So what did the court say? The court says it seems that a court faced with choices as to multiple interpretations of statutory provisions needs to have an orienting filter that guides the options that are best suited for the circumstances. A filter that demands priority in Caribbean states is the basic deep structure and core constitutional values and principles. It is by now uncontroversial that this court, whenever faced with multiple legitimate choices as to the interpretation and application of law, that it will choose the approaches that most align with relevant, applicable constitutional deep structure values, human rights principles, and international obligations and standards. And in another case, OO and BK, the court would consolidate that was the apt approach. And so this means that in Anglo-Caribbean constitutional democracies, all statutory interpretation must include a consideration of whether the law as stated can be interpreted in a manner that is consistent with the Constitution. And that actually accords with what we call the supremacy inconsistency principle. Constitution is supreme, and any law that is inconsistent with it is void. Fifth, this yields something that we describe in the court as the modification first approach. In Barbados, basically this means that the modification first principle applies to all pre-independence law. The principle mandates that in construing these laws so as to bring them into conformity with relevant constitutional provisions and principles must be the task of adjudication. And so what you do is, when you look at a law, if it is a pre-independence law, if it is not in line with the Constitution, then you modify it. That was a case from Barbados, and the approach has been the same in Guyana by the court. Sixth, gender judging. This is an approach to adjudication that is methodologically gender sensitive, but it approaches this gender sensitive adjudication through constitutional values and principles and relevant social contexts. And so the court would articulate what it called a hermeneutic of suspicion and an inquiry into adverse effects methods of legal interpretation. Basically, what it meant is that where you have a law which is, say, pre-independence law, and the context is one in which on the face of it, it could be because of social context considerations, discriminatory, or in relation, in the case of Nicholson and Nicholson, of gender, then you have to approach it with this hermeneutic of suspicion. A law student, undergraduate law student from Mona Law in the Caribbean in September 2025 would write about Nicholson and Nicholson, quote, Nicholson and Nicholson, a land rights dispute, represents a seminal case study in the application of the CCJ's right-centric constitutionalism, which is unapologetically decolonial. The case sets a significant precedent for deconstructing and disrupting historical legal methods, highly susceptible to unconscious gender bias and patriarchal mindsets that have rendered discrimination invisible and normative, especially for historically marginalized groups, where if not scrutinized through a hermeneutic of suspicion, they would continue to perpetuate inequality and injustice. The person who did the brief says, Justice Jamadar provides substantive comment and instruction on the application of this methodology using a gender-sensitive adjudicatory lens to simultaneously uphold justice and address systemic inequalities. So again, what you see is that the court's gender-sensitive developmental jurisprudence is grounded in a right-centric, right-privileging approach that gives priorities to these constitutional values by applying this hermeneutic of suspicion and so on. And the court did say that this is not just limited to gender, but applies to all historically disadvantaged groups that may be affected by statutory provisions, therefore giving it a broad application. Seventh, and I'm coming to the end, the CCJ has explained the need for constitutionally driven approaches to social justice issues, a different category now. In a case, CGI versus Stevenson, the court applied its collective judicial mind to this question: how is Caribbean social justice legislation to be interpreted and applied in Caribbean constitutional and social context? Court would posit 4 principles, which I'm not going to burden you with. It's in the background paper because time doesn't permit. But basically, these 4 principles posit that social justice legislation is legislative policy, and therefore it must be read and understood in social context and constitutional context. Secondly, that the first principles methodological approach is apt, meaning that you should not be too burdened by precedent because you are looking at this through a constitutional lens. Third, that social justice legislation should be interpreted purposively and generously to give the fullest remedial protection to the intended beneficiaries, because that's what social justice legislation is intended to do, to bring benefits to certain groups. And fourth, social justice legislation should be, where possible, interpreted practically, pragmatically, and with a fair measure of juridical common sense. I wouldn't deconstruct that for now, but those were the 4 principles. So the last one is the question of preambular values, and in this there's a bit of a divergence with the JCPC, a very recent decision which came out last week on the 8th of October in Hamilton, the Corporation of Hamilton versus the AG of Bermuda. The JCPC would say that it parts company with the CCJ on the use of these preambles. For the CCJ, the preambles are important in the task of the interpretation of both the Constitution and of laws. And that is simply because Constitution is sui generis, but also because of the independence project was to break with the past and develop for the future. And so constitutional preambles are thought to be of great salience in the task of constitutional interpretation because they create the framework upon which constitutions emerge. I'll end this little point by quoting from Justice Witt in Joseph and Boyce, in which he speaks, right in relation to the Barbados Constitution. He would say, it is in this preambular light that the Barbados Constitution as a whole has to be understood and interpreted. And so right away, you see that the CCJ is quite clearly taking this constitutional, right-centric, right-privileging approach, starting with constitutive principles, deep basic structure values, principles and structures, preambular values, standards, principles, the text, privileging fundamental rights, and then applying that in intra-constitutional and inter-constitutional contexts. If you have to interpret the Constitution within itself, the hierarchy of values is you prioritize and privilege human rights. When you apply other laws, similarly, and that is why it's called Chaastic, because it is a radiating, it's coming from a epicenter, which is the constitutional fundamental rights, and it is radiating throughout the legal order. And so in a very real sense, the CCJ's developmental jurisprudence puts the Constitution and fundamental rights not on the periphery in the activity of interpretation and application of law, but at the very center. And if you can imagine a wheel with spokes, you know, those wheels from a little while ago before we had cars and tires and rims, consider the Constitution at the center, the hub. And at that center, you are privileging rights and freedoms. But radiating out from that center, those rights and freedoms permeate the whole legal order, which we can imagine as the rim of the wheel, then the sort of circumference. And so that is what we mean by the chaastic approach to the making, interpretation, and application of law. There's a risk and price to pay for emancipation from any kind of slavery, including mental slavery. And that's because the status quo resists it so strenuously. And I think in the global south, we know that very well. This is no less so in Caribbean islands of sea and surf and sand. After all, and I quote from Lovelace in a piece called The Hill, quote, "Who is I to die for people who ain't have sense enough to know that they can't pelt a man with big stones when there are so many little pebbles lying on the ground?" Powerful metaphor. We want to change things, but we don't always have the confidence or the courage. Neither do we necessarily want to take the risks or pay the price, because being pelted with big stones can hurt a lot. Caribbean freedom is still a fraught enterprise, as is Caribbean jurisprudence. Yet just maybe the CCJ's developmental approaches to Caribbean constitutionalism can help lead the way, and in so doing illuminate the folly, I call it, of more undevelopmental approaches. And in this illumination, just maybe, the weight and drag of presidential past can be overcome. The power of inapt status quo doctrines, such as unjustified applications of stare decisis or the presumption of constitutionality, may finally be seen as blocks to the freedom that they are and that we long for. And so in speaking of today and looking into tomorrow, for a truly liberating Caribbean jurisprudence, I suspect the question will likely remain for some time to come. As we say in the Caribbean, and I quote, "Is the juice worth the squeeze? Is the juice worth the squeeze?" And time alone will answer that question. Thank you very much for your patience and your indulgence, and Professor Newman Riot, the opportunity to share my thoughts with the Global South Network and all of its supporters. Thank you.
Thank you very much, Honourable Justice Jamadar, for delivering a very insightful and interesting lecture. Indeed, it was an honor to have you during the Global South Network Judges Guest Lecture Series. And I really like the idea of dragon and the dragon dance. I think it's I completely agree with you. It's not only in Caribbean, it's in many other jurisdictions of the Global South. I would now like to open the floor to question and answer. First question for our Honourable guest speaker is, the Caribbean Court of Justice operates within a unique framework that balances regional integration under the Caribbean community system with national sovereignty. How does the Caribbean Court of Justice manage this delicate balance between respecting national constitutional identities and promoting regional uniformity in legal interpretation and governance across Caribbean community member states?
Yeah, I think that's an excellent question, and it's excellent because on the one hand, I have spoken using the metaphor of cuisine in the Caribbean. They are distinct flavors. And if we are therefore to use that idea of differences as natural as breathing, how does a court comprised of the same judges adjudicating both in regional and in territorial hearings balance what can become what I call the imperial magisterium to universalize the law, which in a very real sense the JCPC did with all of its territories, right? When it administered the law as the Judicial Council. How does the CCJ not fall into that model? And I think the answer lies in self-awareness. So that I think it is unrealistic to suggest that that cannot or will not happen, because you are sitting in these two capacities, but you're also sitting as the apex board for several jurisdictions. And so there can always be this tendency to want to universalize for consistency, predictability, and regional integration, have similar approaches. But I think there is enough wiggle room to have commonality with nuance. And I think that's actually a human rights thing, because we need to regard and respect the individual sovereignty of each nation state. Yeah. So regrettably, for whoever posed that question, there's not a straightforward answer, yes or no. And so I think it is a self-awareness of the court, and through that self-awareness, having the skills and the capacity to nuance their judgments. I hope that's helpful.
Thank you very much. Yes, it is helpful, and I'm sure they will find it very useful. The next question is from a PhD candidate, School of Law, University of Edinburgh, Amanullah Amazai, and he's thanking you very much for the informative presentation. And the question is about legal pluralism in the Caribbean region, which was mentioned in your presentation, and he wonders whether the CCJ deals with customary law and decisions of informal justice mechanisms. And he appreciates your thoughts on this, and in particular, he wonders whether the existence of different legal accounts, such as informal justice, is a sign of and because of the weakness of the state legal system.
And the simple answer to that is basically no. Unlike, for example, in Nigeria or North African states, where you have coinciding, you have the national legal order, which is actually the sort of most hierarchically supreme sort of legal system. But you have within that, you have, say, Sharia law, which may deal with property and family. But then you also have customary and tribal law, which in Nigeria is recognized in the Constitution, but in other North African states is actually not recognized formally, but acknowledged in the due process. And so within customary law or tribal law, for example, not in Nigeria, in other North African states or African states, that is, say, relating to marriage and succession and property, the courts pay certain deference to that, even though that is not formal. We do not have that in the Caribbean. That's not been our system. What we do have is a different sort of tension, which I explained. In St. Lucia, for example, there is a civil code. So that's a hybrid legal order between common law and civil law traditions, but not the customary law that I think the question is pointing to. And as I pointed in Guyana, you have Roman Dutch law because of colonial antecedents that informs, for example, the property law in Guyana. But again, that is that's not a customary legal order. Yeah.
Thank you. Next question is, in your lecture, you refer to the CCJ's developmental approach to constitutionalism, one that integrates legal interpretation with the pursuit of broader societal goals. Could you elaborate on how the CCJ conceptualizes developmental constitutionalism in practical terms, particularly in cases addressing socioeconomic rights, access to justice, or environmental sustainability?
Yeah, no, again, very, very good question. In the governance model that the written constitutions have brought into being, there is, again, there's this tension. There's a tension between the executive's responsibility, three branches of government model, executive responsibility to lead policy and also lead the legislative agenda in Parliament. The Parliament is supposed to be passing the laws, and in the classic British model, judges are not supposed to be saying a law is to be struck down. They're supposed to be interpreting and applying, in some senses, sometimes clarifying. All right. The model that has been developed in Caribbean constitutionalism is a model that is necessarily developmental with impact for society and social and economic policy. Why? Because when the executive brings forward a policy and embodies it in law, then the courts have a constitutional power and duty to, if it is found short of, for example, fundamental rights standards or separation of law standards or rule of law standards, to say to the executive and the legislature, well, you've missed the mark a little bit. You know, you overreached a little bit. And it's this the tyranny of the majority point, right? It's, you know, the French writer writing in, I think in 1835 about American constitutionalism, and the idea that even though democracy is about majority rule, well, the majority can constitute a sort of a tyranny of the minority, and the courts are the ones who must now stand in the breach, as it were, and hold the tension. So how does it negotiate it? In answer specifically to the question, it negotiates it through the lenses of constitutional core principles, values, and standards, including human rights standards, but not limited to human rights standards because of something called the basic deep structure doctrine, which says there are certain core constitutional principles which are inviolable: separation of powers. You can't get involved in sentencing, for example. Rule of law, which we kind of understand, the protection of the law, and so on. So that's how it negotiates that tension and space between these three branches of government. But the courts are the final arbiters, actually, of even socioeconomic policy.
Thank you very much. And last final question before we conclude the session. So the CCJ, like many regional courts, must constantly build public trust to establish its legitimacy, especially given its relatively young institutional history. What strategies has the CCJ adopted to strengthen public confidence in its authority, and what role does transparency, outreach, and education play in shaping public perceptions of regional justice?
Yeah, again, these are Professor Rayad, excellent questions, very rich questions, each one of which we can spend a lot of time chatting about. First of all, the CCJ takes the approach that its core work is the hearing and determination of matters brought before the court, both in the original jurisdiction and in the appellate jurisdiction. And so its first strategy, if you want to call it that, for gaining public trust and confidence is the integrity, robustness, and transparency of its jurisprudence. And so, for better or for worse, and time alone will judge that, the CCJ's first priority is in the integrity, relevance, and relevance of its jurisprudence for Caribbean people. And that is something which a court can't judge for itself. People like yourself and others have to determine whether the jurisprudence is bringing legitimacy to the court. So that's one area. The second, and the question raises this, but are there other areas? Basically, that's the question. What about judicial outreach, education? Absolutely. The CCJ from inception basically has evolved organs of the court, as it were, some formal, some less formal, which involve themselves regionally to try and develop and improve and contribute to the administration of justice in the region. So, for example, the court in its current strategic plan, which is about to change, has as a particular strategic goal improving regional justice sectors. So that's a strategic goal of the court. It does so in many ways. Formally, there is something called the Academy, the CCJ Academy for Law, run by senior judges of the court, and it intervenes when requested on a project basis by territories and elsewhere to assist in building up the administrative needs and so on. Very recently, the Academy for Law has initiated, coordinated, and completed something called the Needham Point Declaration, which is an overarching approach to trying to reform criminal justice in the whole region, because crime is a big problem in the region, and that has been well received and has been implemented. The court also has supported, I'm chair of the Caribbean Association of Judicial Officers, and that is an organization of judicial officers throughout the region. CCJ provides administrative and staff support for that CAJO, Caribbean Association of Judicial Officers. But the CAJO, for example, has researched and developed many instruments of practical utility. For example, a criminal bench for Guyana, Barbados, and Belize. We are completing, hopefully by the end of the year, another criminal bench book for Bahamas. We've done research into and developed guidelines for judiciaries to deal with persons with disabilities. We've developed approaches to improve procedural fairness, and so on and so on and so on. In fact, together with different international organizations, we've developed, researched and shared reports around dealing with First Peoples, indigenous peoples, tribal groups, and so on, access to justice. So through these, and I'm using two as illustrative, for example, through these two organizations, the Academy for Law and the Caribbean Association of Judicial Officers, the court supports them, and they work educationally and in outreach ways to fulfill strategic goal number 6, which is to develop regionally and strengthen regionally the administration of justice and the justice sector, and so on and so on. I could say a lot more about it, but I hope that gives a flavor of how the court responds in ways beyond its jurisprudence to help build, to be relevant, first of all, and therefore, consequentially, to build public trust and confidence in the court. Because yes, you are right, whoever posed the question, 20 years is a short time in the life of institutions such as a regional court.
Thank you very much, Honourable Justice Jamadar, for providing comprehensive answers to very rich questions, as rightly you mentioned. Okay, so as we come to the close of the today's Global South Network Judges Guest Lecture, it is my great pleasure and honor to extend heartfelt thanks to our distinguished speaker, the Honourable Justice Peter Jamadar, Judge of the Caribbean Court of Justice, for his illuminating and deeply enriching lecture. Justice Jamadar, your reflections have taken us far beyond the courtroom and into the very heart of what constitutionalism means for the peoples of the Caribbean and indeed for the wider Global South. Your exploration of how the Caribbean Court of Justice has approached constitutional interpretation in a way that is developmental, inclusive, and rooted in local realities reminds us that law is not static, it evolves with the society it serves. Your lecture have shown how constitutionalism can flourish not as an imported ideal, but as a living, breathing framework that grows out of shared history, regional cooperation, and a deep respect for justice and dignity. This message resonates profoundly across the Global South, where many societies are similarly seeking to reconcile inherited legal traditions with contemporary aspirations for equity, development, and self-determination. On behalf of the Global South Network, I thank you for sharing your wisdom and your experience and your passion for the transformative potential of constitutional law. I would also like to express gratitude to all our participants from Africa, Asia, Latin America, Europe, and beyond for joining this lecture. Your continued engagement gives a life to the network's mission, building bridges of knowledge and solidarity between the Global North and the Global South. At the Global South Network, we firmly believe that collaboration among judges, scholars, and practitioners across jurisdiction is not only desirable, it is essential. It enables us to learn from one another, to strengthen our institutions, and to advance a truly global conversation on justice, equality, and human dignity. Once again, Honorable Justice Jamadar, thank you for honoring us with your time and insight. We look forward to continuing this conversation and to welcoming you again in the future. And to everyone who joined us today, thank you for being part of this growing global community. Look after yourself. Have a wonderful day. Bye-bye.
Thank you very much. Bye-bye.